going to read from page 457 of the Disability Rights Law Casebook by Sam Bagenstos. Chapter 5, Private Housing and Public Accommodations. Part A, Coverage. And the first case is PGA Tour, Inc. versus Martin. Justice Stevens gives us the summary, delivered the opinion of the court. This case raises two questions concerning the application of the Americans with Disabilities Act of 1990 to a gifted athlete. First, whether the act protects access to professional golf tournaments by a qualified entrant with a disability. And second, whether the disabled contestant may be denied the use of a golf cart because it would fundamentally alter the nature of the tournament to allow him to ride when all other contestants must walk. Petitioner, PGA Tour, a nonprofit entity formed in 1968, sponsors and co-sponsors professional golf tournaments conducted on 3 annual tours. About 200 golfers participate in the PGA Tour, about 170 of the Nike Tour, and about 100 of the Senior PGA Tour. PGA Tour and Nike Tour tournaments typically are 4-day events played on courses leased and operated by the petitioner. The entire field usually competes in 2 18-hole rounds played on Thursday and Friday. Those who survive the cut play on Saturday and Sunday and receive prize money and amounts determined by their aggregate scores for all 4 rounds. The revenues generated by television, admissions, concessions, and contributions from co-sponsors amount to about $300 million a year, much of which is distributed as prize money. There are various ways of gaining entry into particular tours. For example, a player who wins 3 Nike Tour events in the same year or is among the top 15 money winners on that tour earns the right to play in the PGA Tour. Additionally, a golfer may obtain a spot in an official tournament through successfully competing in open qualifying round, which are conducted the week before each tournament. Most participants, however, earn playing privileges in the PGA Tour or Nike Tour by way of the 3-stage qualifying tournament known as the Q School. Any member of the public may enter the Q School by paying a $3,000 entry fee and submitting 2 letters of reference from, among others, PGA Tour or Nike Tour members. The $3,000 entry fee covers the player's greens fees and the cost of golf carts, which are permitted during the first 2 stages, but which have been prohibited during the 3rd stage since 1997. Each year, over 1,000 contestants compete in the first stage, which consists of 4 18-hole rounds at different locations. Approximately half of them make it to the second stage, which also includes 72 holes. Around 168 players survive the second stage and advance to the final one, where they compete over 108 holes. Of those finalists, about a fourth qualify for membership in the PGA Tour, and the rest gain membership in the Nike Tour. The significance of making it into either tour is illuminated by the fact that there are about 25 million golfers in the country. 3 sets of rules govern competition in tour events. First, the rules of golf. Jointly written by the United States Golf Association, USGA, and the Royal and Ancient Golf Club of Scotland, apply to the game as it is played, not only by millions of amateurs on public courses and in private country clubs throughout the U.S. and worldwide, but also by the professionals and the tournaments conducted by petitioner. The USGA, the Ladies Professional Golf Association, and the Senior Women's Golf Association. Those rules do not prohibit the use of golf carts at any time. Carts. Second, the conditions of competition and local rules, often described as the hard card, apply specifically to petitioners' professional tours. The hard cards for the PGA Tour and Nike Tour require players to walk on golf course during tournaments, but not during open qualifying rounds. On the Senior PGA Tour, which is limited to golfers age 50 and older, the contestants may use golf carts. Most seniors, however, prefer to walk. Third, notices to competitors are issued for particular tournaments and cover conditions for that specific event. Such a notice may, for example, explain how the rules of golf should be applied to a particular water hazard or man-made obstruction. It might also authorize the use of carts to speed up play when there is an unusual distance between one green and the next tee. The basic rules of golf, the hard cards, and the weekly notices apply equally to all players on in tour competitions. As one of petitioner's witnesses explained, with reference to the Masters tournament, which is golf at its very highest level, the key is to have everyone tee off on the first hole under exactly the same conditions, and all of them be tested over the 72-hole event under the conditions that exist during those 4 days of the event. Part 2, Casey Martin, which I think is the facts, outside of the rules. Casey Martin is a talented golfer. As an amateur, he won 17 Oregon Golf Association junior events before he was 15 and won the state championship as a high school senior. He played on the Stanford University golf team and won the 1994 National Collegiate Athletic Association NCAA championship. As a professional, Martin qualified for the Nike Tour in 1999 and 1998. And based on his 1999 performance, qualified for the PGA Tour in 2000. In the 1999 performance, qualified right. In the 1999 season, he entered 24 events, made the cut 13 times, and had 6 top 10 finishes, coming in second twice and third once. Martin is also an individual with a disability as defined in the Americans with Disabilities Act, ADA or ACT. Since birth, he has been afflicted with Klippel-Trenaunay-Weber syndrome, a degenerative circulatory disorder that obstructs the flow of blood from his right leg back to his heart. This disease is progressive. It causes severe pain and has atrophied his right leg. During the latter part of his college career, because of the progress of the disease, Martin could no longer walk an 18-hole golf course. Walking not only caused him pain, fatigue, and anxiety, but also created a significant risk of hemorrhaging, developing blood clots, and fracturing his tibia so badly that an amputation might be required. For these reasons, Stanford made written requests to the Pacific 10 Conference and the NCAA to waive for Martin their rules requiring players to walk and carry their own clubs. The requests were granted. When Martin turned pro and entered petitioner's Q school, the hard card permitted him to use a cart during his successful progress through the first 2 stages. He made a request supported by detailed medical records for permission to use a golf course cart during the 3rd stage. Petitioner refused to review those records or to waive its walking rule for the 3rd stage. Martin therefore filed this action. A preliminary injunction entered by the district court made it possible for him to use a cart in the final stage of the Q School and as a competitor in the Nike Tour and PGA Tour. Although not bound by the injunction, and despite its support for petitioner's position in this litigation, the USGA voluntarily granted Martin a similar waiver in events that it sponsors, including the U.S. Open. In the district court, petitioner moved for summary judgment on the ground that the play areas of its tour competitions do not constitute places of public accommodation within the scope of that title. After noting that the statutory definition of public accommodation included a golf course, the magistrate judge rejected petitioner's arguments that its competitions are only places of public accommodation in the areas open to spectators. The operation of a public accommodation could not, in his view, create private enclaves within the facility and thus relegate the ADA to hopscotch areas. Accordingly, he denied petitioner's motion for summary judgment. At trial, petitioner did not contest the conclusion that Martin has a disability covered by the ADA, or the fact that his disability prevents him from walking a course during a round of golf. Rather, petitioner asserted that the condition of walking is a substantive rule of competition, and that waiving it as to any individual for any reason would fundamentally alter the nature of the competition. Petitioner's evidence included the testimony of a number of experts, among them some of the greatest golfers in history. Arnold Palmer, Jack Nicklaus, and Ken Venturi explained that fatigue can be a critical factor in a tournament, particularly on the last day when psychological pressure is at a maximum. Their testimony makes it clear that their competitive advantage over other players who must walk. They did not, however, express any opinion on whether a cart would give Martin such an advantage. Rejecting petitioner's argument that an individualized inquiry into the necessity of the walking rule in Martin's case would be appropriate, the district court stated that it had the independent duty to inquire into the purpose of the rule at issue and to ascertain whether there can be reasonable modification made to accommodate plaintiff without frustrating the purpose of the rule and thereby fundamentally altering the nature of petitioner's tournaments. The judge found that the purpose of the rule was to inject fatigue into the skill of shot making, but that the fatigue injected by walking the course cannot be deemed significant under normal circumstances. Furthermore, Martin presented evidence, and the judge found that even with the use of a cart, Martin must walk over a mile during an 18-hole round, and that the fatigue he suffers from coping with his disability is undeniably greater than the fatigue his able-bodied competitors endure from walking the course. As the judge observed, plaintiff is in significant pain when he walks, and even when he is getting in and out of the cart. With each step, he is at risk of fracturing his tibia and hemorrhaging. The other golfers have to endure the psychological stress of competing as part of their fatigue. Martin has the same stress plus the added stress of pain and risk of serious injury. As he put it, he would gladly trade the cart for a good leg. To perceive that the cart puts him with his condition at a competitive advantage is a gross distortion of reality. Not every disability is the same. I think the concern is that there's going to be people with other types of disabilities wanting to use carts, and that overall one of them may end up having competitive advantage, making the entire competition distorted. As a result, the judge concluded that it would not fundamentally alter the nature of the PGA Tour's game to accommodate him with a cart. The judge accordingly entered a permanent injunction requiring petitioner to permit Martin to use a cart in tour and qualifying events. The Ninth Circuit affirmed. The day after the Ninth Circuit ruled in Martin's favor, the Seventh Circuit came to a contrary conclusion in a case brought against the USGA. by a disabled golfer who failed to qualify for America's greatest and most democratic golf tournament, the United States Open. The Seventh Circuit endorsed the conclusion of the district court in that case that the nature of the competition would be fundamentally altered if the walking rule were eliminated because it would remove stamina, at least a particular type of stamina, from the set of qualities designed to be tested in the competition. In the Seventh Circuit's opinion, the physical ordeals endured by Ken Venturi and Ben Hogan when they walked to their Open victories in 1964 and 1950 amply demonstrated the purpose of stamina in such a tournament. As an alternative basis for its holding, the court also concluded that the ADA does not require the USGA to bear the administrative burdens of evaluating requests to waive the walking rule and permit the use of a golf cart. Although the Seventh Circuit merely assumed that the ADA applies to professional golf tournaments and therefore did not disagree with the Ninth on the threshold coverage issue, our grant of certiorari encompasses that question as well as the conflict between those courts. Congress enacted the ADA in 1990 to remedy widespread discrimination against disabled individuals. In studying the need for such legislation, Congress found that historically society has tended to isolate and segregate individuals with disabilities, and despite some improvements, such forms of discrimination against against individuals with disabilities continue to be a serious and pervasive social problem. Discrimination against individuals with disabilities persists in such critical areas as employment, housing, public accommodations, education, transportation, communication, recreation, institutionalization, health services, voting, access to public services. Congress noted that many forms of discrimination include outright intentional exclusion as well as a failure to make modifications to existing facilities and practices. After thoroughly investigating the problem, Congress concluded that there was a compelling need for a clear, comprehensive national mandate to eliminate discrimination against disabled individuals and to integrate them into the economic and social mainstream of American life. In the ADA, Congress provided that broad mandate. In fact, one of the Act's most impressive strengths has been identified as its comprehensive character. Hearings on S-933 before the Senate Committee on Labor and Human Resources and the Subcommittee on the Handicap. Sounds like it happened in 1989, which is right before 1990 when it went into effect. Those hearings and accordingly, the act has been described as a milestone on the path of to a more decent, tolerant, progressive society. That's from the Board of Trustees of University of Alabama versus Garrett. To effectuate its sweeping purpose, the ADA forbids discrimination against disabled individuals in major areas of public life among them employment, Title I of the Act, public services, Title II, public accommodations, public services and public accommodations, Title III. At issue now as a threshold matter is the applicability of Title III to petitioners' golf tours and qualifying rounds, in particular to petitioners' treatment of a qualified disabled golfer wishing to compete in those events. Title III of the ADA prescribes, as a general rule, no individual shall be discriminated against on the basis of disability in the full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations of any place of public accommodation by any person who owns, leases, or leases to or operates a place of public accommodation. The phrase public accommodation, as defined in terms of 12 extensive categories, which the legislative history indicates should be construed liberally to afford people with disabilities equal access to a wide variety of establishments available to the non-disabled. It seems apparent from both the general rule and the comprehensive definition of public accommodation that petitioners' golf tours and their qualifying rounds fit comfortably within the coverage of Title III and Martin within its protection. The events occur on golf courses, a type of place specifically identified by the Act as a public accommodation. In addition, at all relevant times, petitioner leases and operates golf courses to conduct its Q school and tours. As a lessor and operator of golf courses, then, petitioner must not discriminate against any individual in a full or equal employment of the goods, services, facilities, privileges, advantages, or accommodations of those courses. Privileges offered by petitioner on the course of on the courses are those of competing in the Q school and playing in the tours. Indeed, the former is a privilege for which thousands of individuals from the general public pay, and the latter is one for which they vie. Martin, of course, is one of those individuals. It would therefore appear that Title III of the ADA, by its plain terms, prohibits petitioner from denying Martin equal access on its tours on the basis of a disability. So because anyone can apply to the Q school, it's public. Whereas those people, if they were just invited to compete in the tournament and it wasn't an open tournament, then this may not be considered public, in other words. So they could close it off and do invitation only as the way around this. Going forward. Petitioner argues otherwise. To be clear about its position, it does not assert, as it did in the district court, that it is a private club altogether exempt from Title III's coverage. In fact, petitioner admits that its tournaments are conducted at places of public accommodation. Nor does petitioner contend, as it did in both the district court and the court of appeals, that the competitor's area behind the ropes is not a public accommodation, notwithstanding the status of the rest of the golf course. Rather, petitioner reframes the coverage issue by arguing that the competing golfers are not members of the class protected by Title III of the ADA. According to petitioner, Title III is concerned with discrimination against clients and customers seeking to obtain goods and services at places of public accommodation, whereas it is Title I that protects persons who work at such places. As the argument goes, petitioner operates not a golf course during its tournaments, but a place of exhibition or entertainment. And a professional golfer, such as Martin, like an actor in a theater production, is a provider rather than a consumer of the entertainment that petitioner sells to the public. Martin, therefore, cannot bring a claim. Okay, so they're trying to say Title I is ruling, not Title III. Martin, therefore, cannot bring a claim under Title III because he is not one of the clients or customers of the covered public accommodation. Rather, Martin's claim of discrimination is job-related and could only be brought under Title I. But that title does not apply because he is an independent contractor, as the district court found, rather than an employee. Which means what? I'm surprised to see there's a different treatment there that I didn't hear about in Chapter 1. The reference to clients or customers that petitioner quotes appears in Title 42 of the United States Code, Section 12182B1A, Romanet 4, which states, for purposes of clauses Romanet I through Romanet 3 of this subparagraph, the term individual or class of individuals refers to the clients or customers of the covered public accommodation that enters into a contractual, licensing, or other arrangement. Clauses I through 3 again of the subparagraph prohibit public accommodations from discriminating against a disabled individual or class of individuals in certain ways, either directly or indirectly through contractual arrangements with other entities. Those clauses make clear, on the one hand, that their prohibitions cannot be avoided by means of contract, while Clause 4 makes clear, on the other hand, that the contractual relationships will not expand a public accommodations obligations under the subparagraph beyond its own clients or customers. The petitioner recognizes Clause 4 is not literally applicable to Title III's general rule prohibiting discrimination against disabled individuals. Title III's broad general rule contains no express clients or customers limitation. And those sections provide that its limitation is only for purposes of the clauses in that separate subparagraph. Nevertheless, petitioner contends that Clause 4's restriction of the subparagraph's coverage to the clients or customers of public accommodations fairly describes the scope of Title III's protection as a whole. We need not decide whether petitioner's construction of the statute is correct because petitioner's argument falters even on its own terms. Okay. So, if Title III's protected class were limited to clients or customers, it would be entirely appropriate to classify the golfers who pay petitioner $3,000 for a chance to compete in the Q school and, if successful, in the subsequent tour events as petitioners, clients, or customers. In our view, petitioners' tournaments, whether situated at a golf course or at a place of exhibition or entertainment, simultaneously offer at least two privileges to the public, that of watching the golf competition and that of competing in it. Although the latter is more difficult and more expensive to obtain than the former, it is nonetheless a privilege that petitioner makes available to members of the general public. In consideration of the entry fee, any golfer with the requisite letters of recommendation acquires opportunity to qualify for and compete in petitioner's tours. Additionally, any golfer who succeeds in the open qualifying rounds for a tournament may play in the event that petitioner identifies one set of clients or customers that it serves spectators at tournaments does not preclude it from having another set players in tournaments against whom it may not discriminate. It would be inconsistent with the literal text of the statute as well as its expansive purpose to read Title III's coverage, even given petitioner's suggested limitation any less broadly. Our conclusion is consistent with case law in the analogous context of Title II of the Civil Rights Act. Title II of the Act prohibits public accommodations from discriminating on the basis of race, color, religion, or national origin. Citing Daniel versus Paul, applying Title II to the Lake Nixon Club in Little Rock, Arkansas, we held that the definition of a place of exhibition or entertainment as a public accommodation covered participants in some sport or activity, as well as spectators or listeners. We find equally persuasive two lower court opinions applying Title II specifically to golfers and golf tournaments. You have Evans versus Laurel Links, Inc., a class action brought to require a commercial golf establishment to permit black golfers to play on its course. The district court held that Title II is not limited to spectators if the place of exhibition or entertainment provides facilities for the public to participate in entertainment. And the second district court case is Wesley versus Savannah. The district court found that a private association violated Title II when it limited entry in a golf tournament on the municipal course to its own members, but permitted all and only white golfers who paid the membership and entry fees to compete. These cases support our conclusion as a public accommodation during its tours and qualifying rounds. Petitioner may not discriminate against either spectators or competitors on the basis of disability. And Section 5 is, I believe that that was the conclusion, is that it's scoped in. And I guess they're going to affirm. And they just skipped directly to the dissenting opinion, which is too much for this recording. Thanks.